Number one.
I am for the petition.
I am appealing for this petition.
Lordship, this is Lordship, this is the renewal of my anticipatory bail application, Lordship. My anticipatory bail application was turned out 5th March 2020, 5th March. But while considering my now the contention is where is the given circumstances or what relevant point has not been considered. Now, Lordship, in this case, there are other accused persons who are already been enlarged on bail, and this accused petitioner in the order sheet, the coordinate bench mentioned that there was a criminal antecedent. But Lordship, I vehemently states that there was no criminal antecedents of this accused petitioner, first of all, and secondly, Lordship, the liberty of the accused petitioner was deprived only on the consideration that he had a criminal antecedent, and the name of this Lordship appeared from the mouth of a co-accused. And Lordship knows far better than me.
Where is the translated copy of the FIR? It's in English.
It's
Right?
English.
Lordship, the synopsis is there, Lordship.
You have not given a copy of the FIR.
No, this is in the CD.
In the city, is that?
Why don't you annex a copy of the FIR? What is the big deal? How much has been recovered?
5,000 bottles of cough syrup.
Pencil.
Kodai.
From?
From
Dharmender Singh, from Dharmender Singh, Shiv Kumar, all of them have been enlarged on bail.
What is the allegation about you?
Statement of the co-accused, and after the charge sheet, there is no evidentiary value of the statement of the
from whom the contraband was recovered. They named this petitioner that he is the partner of that accused person.
So there is no recovery from
no recovery.
No, it is anticipatory.
He is not arrested. He is not arrested.
And Lordship, another important point is also there. That is,
second anticipatory bail.
Lordship,
Yes.
I have no criminal antecedent. First of
We
all,
don't know.
co-accused, and the most important thing which vitiated the entire case, Lordship, that is the sample which was seized.
At this stage, at anticipatory bail stage.
Simranjit Singh, Lordship, Honorable Apex Court, while considering the bail application, the Simranjit Singh.
Bail or anticipatory bail? Bail or anticipatory bail?
That was bail.
Therefore, I said,
Lord,
at this anticipatory bail stage.
Far better than me, that the deprivation
There is
of the
no
liberty.
question of second anticipatory bail. This is a recording of fact regarding there being a criminal antecedents.
Lordship, let the state say that whether there is any criminal
Even if
antecedent.
there is no antecedent, what difference it will make?
If there is no criminal antecedent, Lordship, that means on
That is not mentioned in the CD. In that case, I have to call for the report from the concerned police station that whether he has any previous antecedent or not.
Though this is a second prayer for anticipatory bail, comma, which this court prima facie is not inclined to grant.
Yes. Visa is appearing, but
Not today.
no, possible.
No, not today. No Passovers in bail matters.
Number three, for the petition. For the direction to file message, the type copy of the last information. This is a case under section 363, 365, and my lord, the 34 of the Indian Penal Code. But the petitioner number one is the mother of the principal accused. Petition number two is the uncle of the principal accused, and my lord, the petitioner number three is the father of the principal accused. My lord, there is a love relationship between the victim girl and the principal accused, and my lord, subsequently they are fed up. And my lord, the family member of the principal accused has been arraigned in the affair.
So there is no named accused in the FIR.
My lord, there is a code name, if I name
The last portion it is written, name of the.
That's all.
That's it.
What is the role
Because
assigned?
this FIRs are drafted by the scribes, my lord. Now, the way they, most of the cases, my lord will find that it's written in such a way. The facts is written, and in the last, against whom they have lost the obhijog, means the complaint. That is it.
So what is the allegation against?
My lord, the allegation is he is not the, they are not the principal accused. Principal accused is one Alamgir Mia. And that is in the 161 statement, and girl is aged about 16 plus. So in Muslim, they are Muslim, my lord, belong to Muslim community, and their majority is counted as per their puberty, my lord, when they reach their puberty, my lord. Puberty. And puberty is a biological process.
So who is before the court?
The father, the
Uncle.
mother, and uncle, no?
uncle of the Alamgir.
So in the FIR, in the narration, nothing is said about Alamgir. Nothing.
Alamgir is the prince. Alamgir is there.
So how do we know? That is what I'm trying to understand.
No, she has stated that the accused number, with accused number one, he has played away. He has kept kidnapping.
Where is that? I don't find it in the translation.
Well, the CDs are just down.
That's not the point. That's why I'm asking. I asked you all the other day also that please give a translation. Don't give a summary of the FIR. So where have you said about accused number one? Please show.
My lord, from the last four line.
Yes.
The accused person informed us that the accused person one had kidnapped the minor girl of the complainant by the help of
They informed you that accused number one has.
In the below it's written accused
At
number
the last.
At the
Yes,
last.
my lord, because at least
1, 2,
the
3, 4.
allegation that the father of the victim girl came to know from some person
That
the-
I have seen. He has gone on 20th. She has gone to school. She has not returned. Next day you have found out that she is. So what does she say? How did they go to the accused person's family? Why did they suspect about this family? What is
She has not been recovered.
why did they suspect about this family? What does it say in their fire?
No, it is only said this, my lord, nothing other than my lord.
In the evening, she did not return from a school. After that, we went for searching her every relative, and we also contact with mobile phone, but not found any information. Subsequently, as per so in the morning, a trustful person informed us about our daughter. What has been said?
Yes, sales.
Huh?
He has heard from someone.
Oh, is that a fact?
Well, that is the fact. That is the fact what he has said.
Who is that trustful person?
My lord, the Bishwasta Sutra cover. That is my lord means a trustworthy person have been informed that the accused person one have been kidnapped the minor victim girl with the help of these three petitioners. My lord. That is the only allegation against me.
So has not been added.
No, my lord, as because the victim has not yet recovered.
As per allegation made in the FIR, There's no material in the case diary also. In the investigation also, nothing has emerged, comma till date.
Item number 4.
Item 4, I am praying for not to do.
Not.
Item number 5. Lordship, may please, for the petitioner in this matter. Lordship, I am led by Mr. Anand Mandani, my senior, it is not well. Lordship. If the matter can be fixed on the 30th or next circuit.
As paid next
Next
circuit.
Yeah. Item number 6.
Item 6, I am praying for not to do.
Not to do. As paid not to do.
Item number 7. About the statement.
None appears, not today.
Item number 8.
Lordship, I am for the petition. Your Lordship, this is a case of consensual sexual relationship. The victim lady is a married woman and aged about 34 years. They are used to live together under the same roof since the year 2021. In the meantime, they are blessed with a son, and subsequently dispute and defiances cropped up owing to some financial transaction as well as the property. That's why this case has started. And out of the 3 accused persons, 2 co-accused persons have already been granted bail by the learned lower court, and charge sheet has already been submitted.
Co-accused? She was living with you.
Yes,
So who is the co-accused?
father of this accused petitioner and the wife of this accused.
So it is your flat that she has purchased.
Yes, you're.
Where is the bail order of the other 2%?
Other queries first granted by the London lower court that is got to be honestly, the certified law.
In February,
Your lordship.
there is no proceeding under 82, 83.
I consulted the medical examination of the lady.
No, that is not very relevant. Whether since February there is any,
No.
no.
Lordship, medical denied, Lordship.
What is there?
The
This is of the accused? No.
victim lady.
Item number 9.
9 item. But this is the translated copy of the.
I am for the state.
But the allegation is of hurt. Complaint has been lodged by the father of the victim. What is important has been dealt with in the order granting bail to another accused at page 12.
Last line is not visible.
The last line. The line at the bottom.
Yes.
No, my lord, that is I think Lord,
Show it.
last-
Show it.
Lord, it ends with the word dash. There is no words up. There are no words after that.
Ganesh is your co-accused.
Yes, ma'am. Ganesh is my son and the co-accused. Kindly takes up the order granting bail to Ganesh Milot at page 12.
So Ganesh is your son.
No, my lord, I'm sorry, my brother's son.
Your brother,
My
your
brother's son.
nephew.
Yes, my nephew. Allegations are not omnibus against both of us. However, this incident has been preceded by another incident where the minor daughter of the present petitioner was sexually assaulted by the victim of this proceeding. Which is why this entire chaos happened.
So they have lost the case under POXO also.
Yes,
The victim side, the
Yes.
accused side.
yes. The present petitioner's daughter was
No,
sexual-
niece.
No, my lord.
Petitioner's minor sister, it says. Ganesh's sister.
Yes, yes.
So it must be the niece, not.
Yeah, yes.
What is any distinguishing feature?
Both stands on the same footing.
Yes, heard learned counsel for the petitioner and the learned counsel for the state.
Number 10. Lordship, I am for the petitioner clause. Involving section 345, 323, 325, 307, 34 IPC Lordship, except 307, all sections are available. All the accused petitioner Lordship granted bail Lordship. Kindly see the page number 40 Lordship, charge sheet. Charge sheet submitted Lordship. Page number 1, my.
He is not named in the FIR.
No, Lordship, they are named in it. Named in it. Lordship, last.
Accused number
Last number, Lordship, accused number.
7. Yes, 7. And who, somebody has been allowed anticipatory.
Yes, there is a division to group Lordship.
Who has been allowed anticipatory?
Lordship, kindly page 40 Lordship, all the petitioner are on bail Lordship. On 3.
Bail, you are here for anticipatory bail. There is a knife assault on the informant and her husband both.
One day accommodation, I will bring the copy.
Bring it. As paid by petitioner's counsel.
Actually, in the year 2019, Chashi is filed, but till date he is not appearing. There any proclamation or something maybe.
Find out. Since the charge sheet is of 2009, Land State Council submits that 2019, he submits that he will find out whether any steps have been taken for proclamation. Stop. Matter be listed on. When do you want it? Thursday?
Thursday.
This is the date of Thursday.
Thursday. We didn't. Lordship train को short pass हुआ उससे.
Not today.
Item number 12.
None appears, not today. Next. None appears, not today.
For short pass.
12.
My lord, I am for the petitioner. Item number 13.
Item number 13.
Yeah, why are you right now? Please wait as paid. Yes.
Item number 13.
Item number 13, I'm late by Mr. Shande, he's appearing virtually, Your
My
Lordship.
lord. In this case, my lord, allegations are section 137, subsection 264, 115, subsection 235 of the Bharatiya Nyaya Sanhita, along with 6 POCSO. My lord,
there is a bail granted to the petitioner by the London Sessions Court, anticipatory bail conditions imposed. But we filed an application for cancellation of that matter, that bail was never cancelled, but additional conditions were imposed by the London Sessions Judge.
Where is that order?
But the order at page 1, 2, 3. But only the issue is I don't want to trouble your lordship because I think it's not maintainable. Because they have invoked order 430 and 1B, which can be ordered by an order of the London magistrate. Here the order was passed by the London Sessions Judge, where I was a party. I am not being made a party and no revision filed, my lord.
Where is the order under?
123, page 123.
123.
Lordship, this is my petition. May I, page 45, Lordship.
Page 45.
45. There are two orders passed on the same day. Page 45, Lordship. Order dated 25 February 2025.
Yes.
Kindly says this is the cancellation of bail filed by the intervener, at present intervener, which was rejected. So this part we are writing, Lordship.
Because is the issue of demand, if I may just complete and take 30 seconds of the launch. The Lordship has seen the order was passed by the London Sessions and in a cancellation application which was filed by me. If I may just request my lord to see my lord 439 1B, which was invoked before your lordship, my lord. Your lordship has read it 1,000 times, my lord, just for my satisfaction, my lord. I'm sorry, my lord, I'm troubling your lordship. My lord, 439, High Court, special power of High Court or Court of Sessions regarding bail. Subsection 1, sorry. A High Court or a Court of Sessions may direct A, that any person accused of an offence and in custody may be released on bail. My lord, we are not on that. Then the B says that any condition imposed by a magistrate when releasing any person on bail is set aside or modified. Here, my lord, the order was imposed by the learned sessions judge in a cancellation application, my lord, by which my learned friend is aggrieved. Then in that case, my lord, he has to file a petition before this honorable court, my lord, not 413 and 1B, because that is absolutely forum specific.
Yes,
Lordship. May I, Lordship, I'm giving reply to this.
first that, then anything else.
Lordship, courts, or power, High Court's power,
Read the section, sir.
yes, Lordship, magistrate, I've seen magistrate.
These are coordinate jurisdiction.
So,
And that in
Em-
effect, although the court has held that you have no locus, but it has,
not me, he has no locus.
he has no locus, but then something has been done already.
You will also be filed.
I'm not on that, Lordship. Kindly see page 22.
What is it?
For the, I am being aggrieved by page 22.
What is page 22?
22 is my modification, which I have filed.
That your modification for what?
Bail order,
What effect?
conditions of bail.
What are you aggrieved by?
Yes, Lordship. Magistrate while granting bail.
Therefore, the court has in effect allowed his prayer. Although it has held that he has no locus to say anything,
Lord,
still it has been allowed.
Lordship,
Apart from restraining you from entering the nursing home, now he says you can't enter the area without prior
no,
permission.
that was not his prayer.
Whatever it
Whatever it
is this the jurisdiction where it is to be examined? Please don't go on merit.
Lordship,
Just give
Lordship.
address on the jurisdiction.
Then against the order of the magistrate, then as per we should file an application before the High Court. Now, as because the order has been passed by the
Magistrate, this is a session judge
no,
order.
as because the order has been passed by the session judge, so it should be CR as per to him.
These whatever he has submitted, he has submitted. I am asking you, how do you get over this?
I'll come to one.
All right, can come to. Issue of only of maintainability here.
I'll join online with you.
Prima facie, the order itself appears to be unique. The court says they have no jurisdiction, still it has altered.
And,
But that is-
another order is was there, Lordship.
The point is of jurisdiction, sir. Please come prepared on
Lordship,
jurisdiction.
Okay, I got it.
But I am for the de facto complaint.
In this case,
Yes, yes.
then you also examine the issue.
I will. That's why I asked my learned friends, though we have been
Because that-
adversary.
No, that's all right.
Since a question of law has come up, we have. to
On
look
that, we
into it
should
and
not
come back.
commit an error. Therefore,
Yes,
let us
yes,
be
yes,
clear on the point of jurisdiction, then of course.
Correct, correct,
Yes.
correct.
Then tomorrow we.
Yes.
Friend or out of this.
Out of list. As per next circuit.
copy is not yet.
She doesn't want to expedite her application. What can you do? Aspirate.
For
Next circuit.
the next step. Appearance. Item number 17.
No matters. Yes. Let us see. Not today. Let us see.
Sir, when last time Mr. Justice,
Yes.
Mr. Justice Bhushan Prasad and Mr. Justice Supratim Bhattacharya sit on this circuit bench, there was some order by mistaking between the parties and the advocate. The matter was withdrawn. I have immediately on the next 4-5 days, I have filed the recalling application. But somehow the file is not here and I have mentioned once in last Wednesday. So I don't know for what purpose the file has sent to the principal bench, where the matter is altogether pending here. So if your lordship may kindly allow, because it is not possible, I tried even in Calcutta.
So there was any terms of settlement?
No, nothing, lordship. That was actually a mistaken fact between some misunderstanding or miscommunication done between the client and the lawyer. It's not even the lawyer's fault. It was just a mistake. So that cannot be recalled without before your.
Yeah, what is the system? Why the file has gone to principal? Find out.
Lordship, can it be placed on Wednesday or Thursday?
Without the file.
No, if lordship may pass an
You
order to
yourself
withdraw-
have said that file is not available. Let us see why it is. What has happened, I don't know the process,
Yeah, yeah.
why it has gone to principal bench, whether this is a normal thing to be done after disposal or let him find out tomorrow.
If your lordship may allow, I can go to the civil judge, and before your lordship will rise before lunch, I can intimate if your lordship, because this client is actually
Go
suffering.
to the civil judge.
Going to civil department, I'm sorry.
Uh-huh.
Before
No,
rising
we'll
to-
find out, don't worry.
And kindly, if Thursday or Friday, any day, because
We don't know,
without
let
the
us see.
recording, I cannot argue on the merit even.
My lordship.
Kindly, lordship, I'm glad.
Find out today itself, as soon as possible.
My lordship, may I permit to mention, my lordship, on previous week, a matter has been mentioned before your bench, my lordship, a matter, my lordship, that matter has not been listed till date, my lord. My lordship, mat 9 of 2024. My lordship, am I audible, my lordship?
Yes, what do you want?
My lordship, my lordship, there is a direction to file report.
But you are not the petitioner, why are you mentioning?
My lordship, I am the attorney holder of the petitioner, my lordship.
How can you be,
mention-
madam? Either he has to appear in person or he has to appear through an advocate. How can he be represented
My
by
lordship,
someone?
My lordship, he is appearing in person, my lordship.
We
only
don't
for
see him.
mentioning.
We don't see him. Neither he was there in court nor he is there today. You are not an advocate. Please try to understand what we are saying. The party can appear in person or he can appear through an advocate. Or if he wants through legal aid, how some relative can represent him in a court
No,
proceeding.
No, my lordship, I am not representing him. Only for mentioning, I am.
So mentioning is not a representation. Yes, call anybody else.
Millard, one Millard, taxation tribunal application Millard for inclusion. Millard is slightly urgent because recovery notice has come up, Millard. I am for the NHPC Millard, it's a public sector company. My account is Millard and under the risk of Millard freezing or Millard adverse proceedings.
Inclusion in the next circuit.
Millard, kindly, if Millard takes it up in course of this week, Millard, any day subject to Lordship's convenience. That is a very short matter, Millard. It's not on merits. It's Millard purely Millard on a technical ground. Millard 10-15 minutes, Millard, any day if Millard can accommodate me. It's a public sector company, Millard, or account.
What
Millard.
is the order? What order has been passed?
Millard, a review application was preferred, that was rejected.
Review under which provision?
Under the taxation, the VAT Act itself. There's a provision for review, Millard, before the assessing authority that was filed. That was rejected. Against that order, we went before the tribunal. The tribunal was not appraised with the facts correctly, and Millard, my application was rejected.
All right, we can take it up day after.
Day after.
Wednesday.
Extremely. But I've annexed the recovery notice also, Millard,
Inclusion
for
on Wednesday. Include it.
Your Lordship.
grateful, Millard.
Please inform who is appearing for the.
I'll serve a notice. Millard,
Serve a notice.
Yes.
Yes.
The additional government leader was appearing.
Wednesday. Is state, suggestion. It is state.
Yes,
State.
it's state.
Lordship, may I praying apology, Lordship? Actually, after completion of the 14, my lord, court number 3 repeatedly called me. So next item was 17, my lord, your bench, single bench, arbitration. Earlier occasion, I was, although copy was served to the opposite.
Tomorrow,
party.
come to.
Lordship, no adverse may kindly be allowed. Otherwise, the client will say ki you are not there.
Who
So
said not there? It's just not today.
Oh, Lordship, no order has been passed. Lordship.
Your Lordship, may I
I
be,
know.
Your Lordship, may I be permitted to mention one matter for arbitration? Your Lordship, it's a habeas corpus matter pending since 22nd of April. Since 7th of April 2025, the husband of the petitioner number 1 is untraceable, Your Lordship. And I would notify it's running as item number 47, Your Lordship.
Tomorrow at the top.
Great, Your Lordship.
Can you inform the APP that APP will appear?
As I have to inform along with Ms. Bidashwati Bose. and
Please
for
tell them.
That's it. The very time to inform him.
Number 1.
That I appear for the appellant.
But I am for the
Last occasion there was a direction to file an affidavit. I'm yet to receive that affidavit.
My lord, there was, I am for the respondent number.
District School Board, Millard, for filing a supplementary
My
opposition.
lord, I am for the district school board. My lord, we could not prepare it within a short time. My lord, we need some time to prepare a supplementary evidence. 2 or 3 weeks time maybe.
What do you want to file?
My lord, some relevant documents was not incorporated.
By way of what affidavit? Supplementary affidavit?
Supplementary evidence in opposition.
On behalf of?
District school board respondent number 6.
Earlier time was granted for the said
My
purpose.
lord, it was for few days. My lord, we could not prepare it. 2-3 days.
So now you need 3 weeks.
3 weeks, my lord. It's for Darjeeling, my lord. Logistic problem, my lord.
Today appellant is present.
Yes, ma'am. I appear for the.
And you are for?
I am for the Millard 2 and 3, the primary board. West Bengal, West Bengal primary.
Another 3 weeks time is prayed for on behalf of respondent number 6 for filing supplementary affidavit in opposition.
I reduce the time.
Comma, for which time was earlier granted on 21/4/25. Stop. It is submitted that instructions are required from authorities who are situate in Darjeeling. So considering the prayer, 3 weeks, matter is adjourned 3 weeks.
Grateful, Lord.
3 weeks next circuit ho jayega. हाँ. Just like I think next to next week. So 3 weeks is good.
Number 2,
My lords, I'm led by Mr. Indranath Mitra. My lords, on earlier occasion, there was a direction to file the paper books. However, it is not ready, my lords. Kindly, we are praying for 4 weeks of time to file the paper books, my lord.
Has paid 4 weeks for filing.
I'm appealing for the respondent.
Next, nobody is there.
Four. Number five.
Yes,
Your Lordship, as per the direction by the order dated 12th, we have filed the paper book, Your Lordship, and we have also served the respondent, Your Lordship. The
you have
matter is-
filed already.
We have filed, Your Lordship. The matter is ready for hearing, Your Lordship, but I'm led by Mr. Kanodia in this matter. He has his legs before principal bench, Your Lordship, and I could not see the respondent.
So what do you want?
I'm praying for next circuit, Your Lordship, for hearing.
Has paid next circuit.
State, Your Lordship. Thanks.
Item number 6. Item number 7. Item number 8.
Eight times for the appellant. My lord, by the previous order while admission, my lord, the direction was placed for the appellants to put in the special messenger cost. Lord, the appellant is a very poor lady, my lord. The entire case was looked after by the legal itself. Even I am taken up this matter in pro bono basis, my lord, if that could be waived, special messenger cost then. So how to do that?
Where's your friend?
No, our service is not yet complete. I have served, it's not yet. But LCR was directed to be called for by putting in special messenger cost.
Where's the earlier order?
Why it has not been solved, does it?
He's coming to say that. Notice has not been served.
No, ma'am. I have sent it, but my lord, the tracking report is showing not delivered. It is on hold.
So what do you propose to do about the notice?
I'll again reserve that.
Serve it, then we'll see.
My lord, for the LCR also there was a direction, my lord, that special messenger cost if it could be waived. She is a wife, divorce granted without alimony.
For 6 months, you have not done
My
anything.
lord, this matter was being placed, my lord, but due to paucity of time, it could not be taken up, my lord. First appeals were not taken up.
For notice, completion of notice.
My lord, it was being listed, my lord, but due to bail, my lord,
6 months it has passed, and today you are telling us you could not take steps. You could have mentioned it that this is the position, we could not do this. It's not for hearing that it is not being taken up, you are saying. Don't make such submissions. We also know what is going on. September, the order was there for serving notice, for depositing a special messenger cost, and all of a sudden in April, you say it cannot be done. In May, almost May. It's been 7 months. You're not interested, it appears.
no, my lord, my
At all.
client, my lord, she has been granted divorce without any alimony, my lord.
And what do you
And
know?
that too under
Now,
an act
now
which is-
7 months have passed. What is the status? You don't know anything.
My lord,
What is
My
the
lord,
status?
We were trying to get this matter.
This is
taken up, my lord.
total inaction on your part. You're not trying anything.
There was a direction to serve the memorandum and condonation, my lord. There's a delay of 440 days. Yes. Lord, appeal against a degree of eviction. $440 days, my lord. Lord, the reasons have been explained because time was, my lord, lost before the wrong forum. Firstly, an appeal was preferred, but before the learned additional district judge's first court. So that was later withdrawn, and my lord, this appeal was filed after that. So time was lost there. Yes, my lord. Yes, he is the landlord. I am the tenant, my lord. Yes, my lord. As your lordships, please. Yes.
Number 11, I'm praying for next circulation. Usually appearing in Procedural, but he lost
Last question, your lordship will ask me to serve a copy of the notice 16 that I have been served. Notice 16, gazette notification 2016, your lordship will ask me to serve that I have been served. Gazette notification 2016, 1st March.
Latest notification.
That latest notification that I have been served. Very good. Fine.
First March 26.
Item number 13. 14. 15. 16. 16.
In this matter, your lordship, I am for the petitioner. This matter relating to compassionate appointment. Lordship, today I am. Yes, Lordship. Lordship, today I am praying for withdrawal with the liberty file a application before the competent authority. Kindly 64, your lordship. 64. Item is 16. WBCT 620. WBCT. WBCT.
Item number 17. 18. 19.
Wonders accommodation.
Milord, item number 19, Milord, I beg to appear on behalf of the respondent, Milord. Milord, no copy has been served upon the respondent. I am praying for.
It's second appeal for admission. Milord, copy will be served after admission.
Milord, I have instruction to appear on behalf of the respondent if a copy may be served upon me, Milord, and place the matter during the next circuit.
I have no right to audience. Not today as per no order.
20. 21.
This is a matter, my lord, your lordship, hard ones. The matter relating to the suit for declarations, my lord, declaring the plaintiff, declaring the tenant of the suit premises matter. My lord, in the earlier official that I have submitted before your lordship that the my lord, in the year 1995, my lord, the landowner, they have already instituted a title suit for eviction of the appellant before your lordship, and that title suit was dismissed on 30th September 2002. Thereafter, my lord, again on in the year 2006, another title suit was filed by the landlord, and that was also dismissed.
Eviction suit was filed in 95.
Eviction suit was filed in the year 1995 by the
What is the
landlord.
case number?
Case number was ES 60 of 1995.
So that was dismissed.
That was dismissed on 30th September 2002.
Yes, then
Again, my lord, a title suit 10 of 2006 filed by the owner for
Yes.
eviction.
yes.
That is dismissed as non-prosecution.
Oh.
Now, my lord, now the appellant before your lordship, who are the tenant, they filed the instant title suit for declarations of their tenancy right. Although my lord, their tenancy has already been admitted in the earlier two suits, which were dismissed, my lord, and they are in force because they did not prefer any appeal out of that judgment and decree.
You were you were defendant in both the title suits.
Yes, I am the defendant on both the title suits.
Show us the order passed in title suit 60 of 95.
My lord, that's why, lordship, my humble submissions before your lordship, the placer may kindly be called
No,
for.
no. Show us the order passed in title suit 60 of 95.
My lord,
That is not part of the lower court record.
my lord, that has been exhibited. That has been exhibited and issue has been framed. In spite of framing the issue as issue number 6 and 7, the learned trial court did not utter a single word in this issue, lordship. Lordship kindly comes to the impugned order of the impugned judgment and decree of the learned trial court. Lordship kindly comes the memo of appeal. Lordship kindly comes the running page 22. 22, yes, 22. Issue number 6 and 7, lordship kindly see. How much issue number 6, lordship has got it.
Page 22.
My lord, it is the certified copy, so my lord, the not paginated. Lordship kindly comes to 1, 2, 3, number 3 pages of the judgment and decree. But it is starting from just next to the page number 7.
Give the internal page of the certified copy. It is at the bottom right corner of the page. Bottom right corner.
Yes, my lord, it is 29.
Bottom right corner.
3, lordship, 3. 3. Issue number 6 and 7, lordship. Now, in spite of framing those two issues, that has not been dealt by the learned trial court. And my lord, one more submissions before your lordship is this, that the tenants, the original, yes, your lordship.
2G has been considered, you are saying not considered.
My lord,
427 has been dealt with in detail.
2G considered, but lordship kindly see
You
the.
said he has not answered the issue. The issue has been answered. He has relied on 2G
My
of the West Bengal.
My lord, the spouse of the original tenant was alive and she is alive and she
You
is.
said he did not deal with the issue. You said all those issue has been framed. He has not said anything.
My lord.
Now you are saying what he has said is not correct.
My lord,
The two are two different things.
lordship, subject to correction.
Yes.
How much title suit number 10 and 2006 is
Yes.
binding and relevant in deciding this suit? This
For
is,
that 2G is not relevant.
yes, relevant. But
Then
these thing, whether these observations of the judgment and decree of the title suit number 10 of 2006
yes.
is binding or not?
Correct,
That-
because you say that it's already you were considered as a defendant. Therefore, now they cannot say you're not a tenant.
Yes.
They have then 2G comes into play. You are not a party. Your father or mother or somebody may have been a party.
Two has my lord, subject to corrections, Lord.
It is very well there. Come to page 7.
Yes.
You read from the second paragraph.
One more thing, Lordship. One more thing, Lordship. That the wife of the my lord original tenant
She is
was
not
alive.
before the court. She
Yes,
is not.
She is she is the party in the suit, Lordship.
She
So
may
if she is the party in the suit and she is
She is the plaintiff.
Yeah, no, my lord, defendant.
Then
My lord,
he doesn't want.
my lord, no, my lord, plaintiff. Sorry, my lord, plaintiff. In the suit, we are the plaintiff, son and the wife. Initially, the original tenant, he died. Then the wife and the sons were substituted. So, my lord, wife is
Wife
there.
and son was substituted where?
My lord, in the title suit, lordship.
In which title suit?
My lord, the present title suit. So, my lord, if she is there, my lord.
See.
Yes.
Who was the defendant in title suit 60 of 95?
Yes, 60 of 95, I was the defendant.
You were which defendant number?
My lord, that document, that 60
You were
of-
not a defendant.
My lord,
It was in the name of your father. Now he is no more.
No more.
Therefore, 2G has been considered by the court.
Considered.
There is a statutory period. Beyond that, you cannot claim anything.
My lord, subject to corrections, lordship, if the
You
wife
are not a
is there-
defendant.
My lord, if the wife is there
So
of the
wife-
original tenant,
Therefore-
then 5 years limitations will not
Correct. So who is the wife of the
Lordship kindly comes to the decree of the suit, my lord, my name is there, my wife's name is there.
Your wife's name will not matter.
No, my mother means my original tenant's
That is,
wife.
then say that you are saying
Yes.
my wife.
No, my lord, Deepali Das.
Where is that?
My lord, if lordship will get from the decree, the 11 is the last page of the title suit, judgment and order. 11. Thereafter, my lord, decree is starting.
Yes.
My lord, kindly, it's a bit illegible. 1A, 1B, 1C, they are the sons of Ajit Kumar Das, and Srimati Deepali Das is the wife of Ajit Kumar Das.
Ajit Kumar Das is the plaintiff here.
Here.
He is not the plaintiff of title suit 60.
No.
Therefore, the 2G insofar as the wife will apply to the wife of plaintiff of title suit 60, not of the plaintiff of the present title suit.
My lord, in the present title suit, my lord, the wife has been made party. The original tenant's wife has been
Just
made.
now said your mother. Where is your mother?
No, my lord, she is the my lord, the present suit, the original tenant was the plaintiff. Thereafter, he died during the pendency of the suit.
Correct.
Thereafter, the three sons and the mother has been
The
substituted.
three sons and your wife, not your mother.
Not my wife, the original tenant's wife.
It doesn't appear so.
My lord, yes, Deepali Das is the wife of the Ajit Kumar Das.
So what is the name of the plaintiff here? The original plaintiff in the present suit?
My lord, the lordship kindly comes to the last page of my the decree of the title appeal.
Yes.
It is more legible.
Wait a minute, just give us a minute. The entire party is not written here. In that case, in the second, that word.
Let's third last page, lordship.
Ah. What is your father's name?
My lord, Ajit Kumar Das. We
Ajit
are
Kumar
the
Das is the plaintiff here.
yes.
What is his father's name?
No. My lord, might be I am not able to.
Yes, you are not
Your
clear.
lordship understand.
Correct, we are not understanding.
My-
Now tell us.
My lord, the original tenant was the plaintiff. His name was Ajit Kumar Das.
There is no ambiguity on that. The
During
case that you are trying to make out is that you were a party to title suit 60. In 60, you have been arraigned as a defendant.
yes.
If he has found you as a defendant tenant, then in this suit, how you can be considered otherwise? This is your
Yes,
claim.
my lord.
So therefore, you have to establish that you were a defendant in title suit 60.
My father, that Ajit Kumar Das,
So-
he was alive at that point of time.
Ajit Kumar Das was the father of the present plaintiff.
Yes, he
That
was.
is not clear to us. How do you say so?
My lord,
Ajit Kumar Das is the plaintiff here. He is not the father of the plaintiff. You see the first page. Come to the first page. Ajit Kumar Das and others.
he was the plaintiff in the instant suit.
Yes.
He died during pendency of the instant suit. Thereafter, three sons who are before your lordship.
Ajit Kumar Das was plaintiff of title suit 60 of 95 or not?
Yes, he was the plaintiff.
We
Even
don't-
my lord, in the
Cannot
present
be.
case, he was the plaintiff.
In the present case, there is no doubt that he was the plaintiff. You need not stress upon that issue.
Yes.
We accept it.
Yes.
You are trying to make out a case that if he was a defendant in title suit 60, then he is acknowledged as a tenant.
Yes.
So where was he a defendant in title suit 60?
My lord, that has been exhibited, my lord.
We don't see it from the finding of the trial court. That is not obvious.
My lord,
You show from the judgment anywhere that he was a defendant in title suit 60 of 95.
my lord,
You read from the judgment.
lordship kindly keep the matter on Thursday, I'll show.
Yes, as prayed. List on, give the date of Thursday. Otherwise, 2G will come into effect. Either the wife of the original defendant or the son of the, then only your point can be made out. Otherwise, it will be hit by 2G.
The judgment and decree of the.
Just show us a copy, yes.
Yes.
Item number 22, my lord, I appear for the appellant, respondent, plaintiff. I was the plaintiff in the suit, my lord, decreed in my favor. And then in the appeal, my lord, it was reversed. I'm before your lordship, my lord.
Suit for?
Suit for declaration and permanent injunction.
It was decreed in your favor.
Yes, my lord. There was an application for condonation of delay that was, my lord, condoned by the honorable single bench.
So why the appellate court has?
Appellate court, my lord, as first, the point of limitation, my lord, was not held in my favor, my lord. We had taken a point that it was filed beyond limitation. Now the learned first appellate court, my lord, held that this point was not taken on the date when the appeal was admitted, but it was taken when the injunction application was moved in the first appeal. But since, my lord, no appeal has been preferred from that order, it was deemed to have been admitted, my lord. Second is the case, my lord, section 34 of the Specific Relief Act was held to be against me, where according to the, may I take a lordship, my lord? My lord, actually, the entire case records were taken.
Oh, it is against arising out of interim order.
No. I'll take your lordship because the entire records were applied certified copy together and it came together, so I could not break, my lord. It will come up if your lordship kindly comes to about 10 pages in the. May I, for your lordship, my lord, it's original certified copy. I could not, my lord, paginate it. From 10, 12 pages. Hmm?
Reference.
My lord says that from the court of the learned additional district, just third court.
At the bottom right corner, there is a page number.
No. Page, these, yes. After that, that is, my lord, of the appeal, that is page 8 of 8. Thereafter, my lord, final arguments. After page 8 of 8, these are the final arguments on behalf of the plaintiff.
That's page 1.
Yes, page 1, then page.
At the bottom, you will get a
Yes,
page
yes,
on
page
every
1,
page.
page 2, thereafter page 3, my lord. These are of all the individual pleadings. After page 3, my lord, kindly sees.
Yes.
The internal paging is at the top here, my lord.
1.
Yes, my lord. The point of consideration starts from internal page 5.
Yes.
My lord, with regard to the limitation point, my lord, my humble submission is that order 41 rule 3A says that the appeal, my lord, shall be accompanied by a application for condonation of delay if it is filed beyond the limitation, which in the instant case has not been. Now, as far as section 34, which was held to be against me, my lord, now
Your admission of possession of the defendants is in the plaint.
my lord, the defendants were not in possession, my lord.
So from the plaint, come to the plaint.
Yes. If your lordship can take up the application for stay, my lord.
Yes.
There it is. We have paginated it. It is
You
at
are relying upon presumption by virtue of land records
as
to
well-
say that you are in presumptive possession is claimed by you. In the same breath, you say that they are utilizing the land by organizing matches and everything, and they are in possession.
Yes.
And that your father could not take any steps to reclaim the possession
From
from
details,
whoever,
the respondent number 8,
from whoever,
who chose not to appear, my lord.
from whoever. So that possession that the possession is not yours is admitted in the plaint, and you seek no relief
No, my lord.
apart from declaration. You seek no relief.
May I, my lord, subject to correction, my lord.
Then 34 bar will come into play.
But in the plaint, I have said the possession is with me.
Well, let us see.
Yes, kindly takes up page 33 of the stay application. my lord.
Yes.
My lords are there. At page 3, my lord, paragraph 3, I have stated, my lord.
My lords, I am representing the respondent number 1 in this matter.
It is appearing for the first time.
Second appeal, respondent.
My lord, yes.
All right, you'll be there. We are not required to hear you.
Actually, my lord, I have not been served with a copy.
We are not required to hear you, please. Hmm. Where have you said about defendant number 8? What have you said about defendant? Where is the statement about defendant number 8?
Defendant numbers, they are, it is in a, the plaint was subsequently amended, my lord.
Where is the
That I
amended
do
plaint?
not have the amended plaint. I tried
Show,
to.
show,
get,
show.
But it is there from the
The
order
court
of
has recorded. The court has recorded. Show it. You have got the entire certified copy.
I have, my lord, but
Show it.
here I could not get the, let me see whether it is the.
You
This
just now you submitted that if at all it was possession of defendant number 8.
Defendant nine.
You don't find
not eight,
anything.
9, and this amended copy is not here. That is the problem, but my lord will find it even in the judgment of the trial court, that my lord will kindly take up the stay application. It is part of the memorandum, but stay, my lord, I have paginated it.
Judgment of the trial court is at which page?
At my lords are at the stay application, my lord.
Yes, you
Yes.
said to take up
Yes,
the
yes,
stay.
yes. Page 15, my lord.
No, this is the appeal judgment.
Of the trial court, my lord.
Page 15 annexure A.
Yes, my lord. This is the judgment, my lord. Which starts? Oh, I'm sorry, my lord. I stand corrected, my lord. I stand corrected.
When we say something, at least have a look before you say no. Yes, yes. Yes, where is it? Let us.
Page 68.
Page?
68.
There is a gift deed also.
Yes, from my father to me. That is how, my lord, I became the owner of the property.
What is the temporary structure which you say they have erected on the plot?
Well, my instruction, my lord, it was a sort of stage for holding football match. Football matches were being held. Some fairs were also being held. Permission was taken from me and I had given permission.
Issue is only of possession.
Yes.
That is admitted that by you, that
That-
they have erected structures on that.
DG, the GTA, present GTA, my lord. But GTA was not there to even.
Point is, can
review.
point is of maintainability of the suit.
My lord.
Defendant will come later.
Yes.
Your prayer that you have articulated, whether it is sustainable under section 34 or not, that is what the appellate court has found based on the pleading.
Because
You say that they were already have erected permanent, some kind of structure on the land. There is a finding to this effect by the trial court also, that you have not challenged. The trial court records that they are in possession, they have erected some structure, but goes on findings of the observations recorded under Order 39 for the purpose of injunction, and saying that all this we have already decided in the injunction, at the injunction stage. There is nothing.
There is
Wonderful,
also
unique kind of an order has been passed by the trial
there
court.
is also a report, my lord.
Now comes the possession with presumptive possession.
No, my lord is referring to the record of rights.
Correct.
No,
The-
I am not on that manner. There is
District
a-
magistrate's report.
Yes, which says that after inquiry, it has been found.
That the lands are recorded in your name.
No, that I am in possession, my lord.
Where is that? Show us.
Yes. It has been exhibited as well. my
Please
lord.
show us where it's from the trial court's order. Where is that finding? We may have missed.
I'll come. That she got it. Mother had already given to PMLA. Then you have an liberation. The duty of one, the level of the level of the duty of the birth, it transfer. That finding is not completely in my favor. I will be candid here. Internal page 16.
We may have missed because we have just gone through it
Yes,
cursorily.
I understand that.
Yes.
So, but my lord, apart from that,
Such a decree based
Yes.
only on a presumptive possession and some findings recorded at the stage of Order 39 to decide a possession in favor of a party.
yes,
So the appellate court has interfered. It says if this was the situation, at least you should have prayed for a recovery of possession, restoration of possession, whatever.
My lord, with regard to section 34, may I come back after 2 months?
Go through a comma judgment. That is the latest judgment.
Before that, there's a 2021 judgment also.
Before that, we are saying a comma is the latest judgment.
Yes, but Akama had discussed it, but not distinguished it. What I have understood.
Kamma has in fact affirmed it. On first blush, it appears to be at a distinguishing,
Yes.
but it is not. It is reaffirming the settled proposition of law.
2021 judgment, my lord, says that even if a decree of possession has not been prayed, but consequential decree prayer for injunction has been prayed, declaration and injunction.
Please show, please
Uh,
show.
Kumar, my lord. And my lord, I will be also, my lord, relying on order 43 rule 1 because without rule 3A. Yes. And also representative or order 1 rule 8, my lord. In as your lordship.
Some argument in terms for the appellant, comma to rely upon certain precedents. 6
The 23 Millard, I am appealing for the respondent.
Yes.
Millard, Millard, having Millard taken instructions, Millard, Millard, there is a fair chance of settlement. So Millard, if Millard, subject to Millard, what my learned friend says, Millard, one attempt in mediation, I think Millard, this can be sorted out.
Well, the thing is that I have, you can also kindly seize my application under order 39 rule 4, Malad, where I have admitted the amount. I have said that I have never denied that I will not sell the land. They themselves approach the trial court and state the and obtain an interim injunction.
We were considering this matter.
No.
This is the first time Millard.
On the basis of
considering.
manufactured agreement, Malad.
Millard, now whatever has happened, Millard has happened. Millard, we cannot turn the clock back now. The
No,
only thing
just
is-
give us, what is the, what it arises out of interim order.
Interim order. Millard,
I made an
interim injunction was granted in my favor. They preferred an application under 39 rule 4 that was rejected. Against
This
that,
arises out of that.
correct. Now, Millard, the subject matter of the dispute is a 26 bighas of land. Admittedly, both the parties are ad item with regard to the total consideration price. And advance was also accepted by them. Token advance.
For sale.
For sale. Now,
15 crore property,
with
11
a-
lakh has been.
with a contemplation that they will exchange the original documents for conducting title search, etc., and then executing a formal agreement to sell. At that stage, Millard,
There was a written instrument.
but there was Millard,
What do you see?
there was
That
a
was
writing.
manufactured to
Millard,
an agreement.
According
Kindly
to
see.
them, that was manufactured. According to us, Millard, that was a piece of paper where at least this much is recorded that against this land, this is the amount you have accepted. So the trial court proceeded on the basis, prima facie, there is a recording of an agreement, even though a formal agreement was not in place.
That agreement is under challenge.
No, that's, they are
Yes.
disputing it.
No, we
They are
are disputing.
disputing it.
No, but you have not put it in question in any suit. You have not done so.
No.
No, they have not filed any suit. An FIR was lodged by them, a counter FIR has also been lodged by them. Well, it's a purely a commercial transaction, Millard, few things here and
How much land?
Millard, 26 bighas.
And how much have you paid in advance?
Millard,
11
11 lakhs have been paid. The total
Out
consideration
of
is
15
Millard,
crore,
15,
60 lakh.
60 lakhs is the total consideration. So Millard, actually Millard, at the time of scrutinization of the documents, Millard, something has cropped up which was not expected. According to us, Millard, they have suppressed it. One of the directors has passed away, they have not disclosed. Some of the portions are Millard encumbered by a proceeding initiated by the SEBI. That is that they have not disclosed. These things Millard has cropped up. So a settlement can be worked out, Millard, to brush aside these things. So Millard, my respectful submission, subject to my friend's consent, Millard can send this for mediation. They can attempt one sitting if the mediation can happen, or they can sit between themselves.
How do you think it can be settled when you are yourself not satisfied with the status of the land?
No, we are satisfied to the fact that out of 26 bighas, according to us, 23 bighas is unencumbered. 3 bighas is encumbered. In addition to that, 11 lakhs advance we have paid to them. After that, Millard, we have taken possession of the land. Today we are in possession of the land. We have leveled it. It was a low land. We have, Millard, deposited a lot
On
of.
this point, do you have any instruction?
I don't have any instruction.
So
But
we are just, please listen to us also. You find out from your client. Because he says whatever dispute, it is in relation to a very small fragment of the total land. For the remaining, if both parties are willing to mediate, then it will go.
Yes.
Then
There
only
is
it
a
will.
scope of settlement, as we understand.
Then let me come tomorrow, Malad.
Why not?
Yes.
Not today.
Mal.
Only you to tell him that whatever issue is arising is only for 3 bighas out of 26. For 23, can we go for mediation? And then before we send it, you will have to establish some bona fides.
Yes, definitely. Whatever falls from your lordship, we will, Millard.
If they are willing to purchase the remaining land, Malad, but that if they don't want to purchase disputed land, the remaining land, they have to, if they agree to that, then it can be.
That is what he's saying.
Can be split here.
That is what he's saying.
You have to sit for that. No, that's
Mediation
what
will
I'm
take
saying.
a lot of time, Malad.
Correct. So that is what he's saying.
No,
He
not
has-
even a formal mediation. Let the client sit
He
for the-
says that I am aggrieved by the status of only 3 bighas of land out of 26.
Yes.
Therefore, the entire thing has come to a stalemate. I am still agreeable for remaining 26. He says for establishing bona fides, he will also do something if required. So you find out if the parties can think of talking over this issue on, if maybe
Kali takes up tomorrow.
tomorrow, as prayed by the parties?
Tomorrow for Wednesday. সময় লাগতে পারে দুজনে বসবে মিলার let it be on Wednesday. I think মিলার something can happen. by
We
that
are
time.
informed by the learned counsel for the respondent that
Item number 27. 27 Millard, pursuant to the last order Millard, the paper books are now ready. Millard, we have to file it in the department.
and serve copies of.
And serve copies also, Millard, this has to go before the next circuit, Millard.
We are informed by Mr. Swenso that paper books have been prepared pursuant to earlier order,
Item number 28.
28, my lord, I appear for the appellant. My lord, by an order of the Honorable Coordinate Bench passed on 1st of October 2024, there were two directions upon me, my lord. First was to put in the special messenger cost and thereafter to prepare the paperwork, my lord.
not done.
Oh, my lord, but kindly.
Which order dated?
1st of October 2024, my lord. At paragraph 16. Paragraph 16 and 7.
Respondents are in appearance.
As a respondent number 1 had appeared on last. Mr. Subhashish Mishra.
The learned counsel for the appellant submits that
Item
26, my lord. Item number 26, my lord. I have missed it. I am in virtual mode, lordship.
For item number 29, my lord, I am for the appellant, my lord, herein.
yes.
I am for the respondent lordship and
The honor last date.
Who is for the appellant
I
in
am for
29?
I am for the appellant, my lord.
In
I am
29.
on virtual mode. I am there, my lord.
In 29?
20.
Yes, my lord. Yes, my lord.
Yes.
And so far,
My lord, there was a direction for the paper book, my lord. On the last
Yes.
occasion, I have obtained the documents, my lord, barring one document, that is the copy of the will, the signature of which I have challenged on the issue that all his life my father used to sign in English, but it is alleged that he signed in Bengali in the that will, my lord. So now, my lord, the problem is that will, the original copy has been taken by the respondents here in, my lord, the plaintiff below. And my lord, there is a photocopy of the will in the record. But my lord, from photocopy cannot be given. That is what is barring the department from giving a copy of that will, my lord. If a direction can be given by your lordship, then that photocopy can be obtained.
Lordship, in case of the COVID proceeding, he raised objection and made contents are, and after contents are, before the district judge, London district judge, they did not appear. Therefore, it gone for expert. And
Are we hearing out the appeal?
No, Lordship, the appeal.
Paper book has to be prepared. What are you saying?
No.
Yes,
As per his person, the will is in my custody, but not in my custody.
All right. So say that only. It is not with you.
It is not my custody because of the exhibit that is under the custody of the district judge.
And what was scan 2 for?
Scan 2 for?
It is disposed of, my lord. One petition was for condonation of delay. That was the can 1, my lord, which was allowed, and can 2 was a stay petition, which was disposed of. The stay was not granted, but undertaking was given by the respondent, my lord, that they will not construct anything on that document, on the subject land. But my lord, if this case is not proceeded with at a little more pace, my lord, then I might lose to the extent that the construction will slowly going on, my lord, and there might be third-party interest also created, my lord.
Don't make some submission which are not born from the records. Please. This is not appreciated at all.
Pardon?
Don't make submission which are not born from the record. They have said they will not proceed further. Have you filed any application that they are still proceeding?
My lord, on the last occasion, it was asked, and that's why the undertaking was taken.
Have you filed any application that in spite of this order, they are still proceeding?
No, my lord, I did
Then
not.
why are you making such submission?
So I do apologize, my lord.
Yes, don't say that, please.
I may be allowed to get a copy of the will, my lord. That is what my paper will be.
Why are you not preparing the paper books? That's the
My lord,
only.
My lord, if I happen to prepare the paper book also, the copy of the will be missing, my lord. I have
Whatever is there in the records of the trial court, only that has to be.
I have the copy of those, but as the photocopy of the will is there.
Whatever is there.
My lord, the photocopy from a photocopy, the department cannot give is what I am informed of, my lord.
Unless you try to do it and you fail, how can we accept such a submission? The paper book has to be prepared only on the basis of the records. Whatever is in the records.
My lord, in the record, there is the copy of the will, but it is a photocopy, my lord.
So,
and photocopy from the photocopy the department cannot give me is what they have informed me, my lord. They can only provide photocopies of the original documents that is there. And this particular hurdle can be only overcome by way of a
This is not
direction, my lord,
something, this is not something unique to your case. This must be happening in all the probate cases.
my lord, if
So
the
in none of the
photo,
probate cases, the paper book is filed without taking the original from the other side.
my lord, that I am not aware of, my lord, but
No, that
without
you
a
have to
copy,
tell us. You have to tell us whether there
my
is
lord,
such a procedure that he is obliged to give you a copy of the genuine will before you present the paper books. Otherwise,
I
in
have
every
tried my,
case, you have obtained an undertaking from him, and now you raise such an issue only to.
my lord, I will file the paper book in this week only. I don't mind that, but
When
my
you
lord,
file
it will,
it, we are not going to record any such thing. We don't know whether
but
there is any such objection raised by the department.
my lord,
You are
but it will
also
not
saying that you don't know for sure whether you have tried to submit. They have said that no.
No, no, my lord. I have tried. I have gone to the department. The department is what informed me that a photocopy of the photocopy from the record cannot be given. Only the original, the photocopy of the originals can be given. And this particular hurdle, I have mentioned this matter also before this court, only to come out of this hurdle. I mean, overcome this hurdle, my lord, for so that I can get the copy of the will also, my lord.
We are not going to do anything. You file the paper book, whatever you have.
As your lordship pleases. As your
For
lordship
filing
pleases.
paper book, further time is required by the learned counsel for the appellant. By way of last indulgence, we are granting 4 weeks time from date.
Much
May I
obliged.
be permitted to mention item number 26, my
No,
lord?
you may not in the midst of proceeding. Please call the next case.
Gratefully.
I am for the appellate one. In this case, it's so happened, Manan, during the last order, there was a direction on the appellant to submit the special messenger cost within 2 weeks, Manan. I could not submit it, and Manan, I pray for an extension of time.
How much?
4 weeks.
For original order 2 weeks.
Another 2 weeks.
Of September, and in April 4 weeks.
As your lordship.
Yes. The order dated 23/9/24 could not be complied with.
It was 31 I'm for the appellant, my lords. Mr. Chattopadhyay is my lords appearing through the virtual mode.
My lord, I'm for the appellant.
Lord, my lord,
Yes, we can hear you.
my lord, my lord, I appear on behalf of the respondent in this matter.
I'm going to stay first.
My lord, this is a first appeal. My lord, this is a first appeal against the money decree, my lord, on account of mean profits. Now, your lordship will kindly take the order dated 2nd August 2024, by which the conditional stay was granted. Now, my lord, pursuant to this order, my lord, they have deposited 38 crores. I mean, the appellant. Now, my lord, there was a direction for filing paper book. Paper book is yet to be filed because in between I have deposited the, my lord, special messenger cost for the purpose of getting the trial court record. but unfortunately there was some discrepancy. Records were sent back to the trial court and it has come back, but no paper book has been filed by the appellant up till now. Now I am, by this application, my lord, I am seeking my lord's leave to withdraw a part of the sum deposited by them against furnishing a counter guarantee. My lord, I am prepared to furnish a bank guarantee for the amount, a part of the amount what they have deposited.
Let him
38
comply
crores.
with the earlier order, then we'll consider the application.
My
Let-
lord, I am for the appellant.
Yes.
Now, my lord, I am, my lord, the arrival of the lower court record is yet to be intimated. My lord, it is required to be intimated, my lord, by the department concerned.
Let us
Now,
see,
my lord,
just a minute.
Lordship, Lordship, kindly come to page 77.
No, about arrival of the records, we are just trying to see.
And my lord, there is no scope of any, my lord, we want to use an affidavit, my lord, so far this application is concerned.
But get the paper books prepared also.
My lord,
now
my
the
lord,
paper
subject to
trial court
Lordship's
records have
subject
come
to
back.
Lordship's kind consideration, my lord, arrival of the paper, arrival of the lower court record, my lord, is required
See,
to be
voice
intimated, my
over
lord, by the
voice
department,
on
my lord,
virtual
only
mode.
on-
Voice over voice in virtual mode does not help anyone. Please, yes, Mr. Chattopadhyay.
My lord, arrival of the lower court record is a precondition, my lord, for filing a paper book. Now, my lord, we are yet to be intimated by the department concerned regarding the arrival of the paper book. Now, my lord, once it is, direction is already there, my lord. Once it is, my lord, intimated, my lord, also kindly direct, my lord, the department concerned.
What is the date of the direction?
My lord, that is, my lord, on
22/8/24.
Yes. August 2, my lord,
page
2024.
At page 77, my lord. Kindly see the order.
My lord, we have secured, my lord, the decretal amount to the tune of rupees 38 crores.
No, that he has just informed us that he
My lord, if subject to Lord's in consideration, my lord, let us, my lord, use an affidavit, my lord, to this application. In the meantime, my lord, let the record be, my lord, intimation be intimated, intimation of the lower court record, my lord, arrival of the lower court record be intimated to us, my lord, in due course, my lord, so that we can all that this application can be, my lord, adding, my lord, suitably dealt with.
In February. February 25. Yes, it was received again, and in February it was found defective, but after that, what has happened? There is nothing. What is the application number?
Application number, my lord, can number 2 of 25. High application.
Oh, should be some direct-
Present application.
Yes.
It's only incomplete. Yes, we are, the Learned Counsel for the appellant submits that he would like to file a opposition to the application filed on behalf of the respondents bearing number CAN 1.
CAN 2.
My lord.
CAN 2.
CAN 2 is CAN 2
CAN 1 disposed of already, my lord.
of 2025, yes.
Actually.
We find from the records that on 2/8/24, there was a direction for preparation of paper books. To stop the office notes as on 27/2/25 reads as follows. You take it from here. Let the office take further steps in this regard expeditiously. Full stop for filing opposition to CAN 2. We grant 2 weeks from date.
I'll make it 3 weeks.
3 weeks from date, full stop. List thereafter.
My lord, I may be permitted to file a reply if necessary. I mean, lordship.
List after 6 weeks. In the meantime, it will be open to the Learned Counsel for the respondent to file his reply.
Lordship.
Yes.
My lord, in the meantime, the appellant will also take steps, my lord.
We have said so. We have
Yeah,
asked the
lordship.
office because the office records that the records are incomplete. But after that, what has happened, we are unable to see.
My lord, the
Let
records
them-
were incomplete. Thereafter, my lord, we were told that it was come back with my lord after correcting that
No, we find one
making the corrections
exercise.
and all
One
these things.
exercise was undertaken, returned. Thereafter, again, it has been received. It says incomplete.
May I submit one thing? May I
Yes.
submit one thing? My lord, let the department concerned be directed, my lord, once my lord check arrival in my lord complete form and my lord examination is completed, my lord, let the appellant be informed, my lord, accordingly.
No, that is already, there is an order of 2824. So
Yes,
therefore,
yes.
we have said to
Yes,
take
yes,
steps
yes,
in
yes.
accordance with
My lord,
2824.
my lord, my
Or
lord, my lord.
expeditiously. Yes.
My lord.
My lord, lordship.
Grateful to your lordship.
Yes.
Deeply obliged.
Item number 32. 32.
32 praying for one day.
Item number 33.
Paper books are not ready. I'm praying for next circuit.
Are you not ready?
Yeah, October of 2024.
October.
Or September.
You are not interested in the appeal. July 24. In 1 year. Nearly 1 year. Do it within 2 weeks. The Land Council for the appellant submits. Sure, give us the file. Call the next case.
Item number 34.
Notice of arrival served in January. For filing paper books. And counsel for the appellant prays for
Item number 35.
35 Melodies, Mr. Sudipta Mazumdar is for the respondents, Melodies. I've just been informed that he is out of station, Melodies. I'm praying for next circuit, Melodies. I'm grateful, ma'am.
Pillar 36. Pillar 36. 37.
37. My lords, in item number 37, the paper book is not ready yet, lordship. I need some more time to complete the preparation of the paper books, lordship. Kindly, if may be allowed, lordship. Lordship, we have deposited the special messenger cost. Yes, lordship. Yes, lordship.
Pillar 38.
My lord, for item number 38, I am praying for today's accommodation.
Your lordship,
Kindly keep the matter on Thursday.
your lordship,
2 days. I thought, we thought you were saying today's account.
Your lordship, the difficulties, they have not filed they have not served a copy of the memo of appeal, your lordship, and because the appeal is pending, long pending, we cannot file a execution proceedings before the court will, your
You are
lordship.
representing which respondent?
I am appearing on behalf of the private respondents, your lordship.
How many respondents are there?
Well, one only, your lordship,
Sole
Shilipuri Nursing
respondent.
Home. Sole respondent, your lordship, I'm appearing on behalf. So, I will just pending here, your lordship, before the honorable court, your lordship. So long as they have not served us a copy, your lordship. You cannot find the execution proceedings before the final court.
You are the plaintiff. You have not, the execution has not been filed.
We could not long time for lordship, right? We have saved of time on several occasions.
For pendency of appeal, you could not file an execution. What prevents filing of an execution because appeal has been filed? There is no such bar. Oh, it's pending. Oh, you, yeah. It's no order. Until now for lower court records. There is no order for lower trial court records or anything till date. There is nothing. It's come up once earlier. Let them be here. We'll direct for, it will have to proceed now. As paid list on Thursday, give the date of Thursday. We'll direct them to file the requisites for the records, and on that day we'll.
Number 39, Lordship praying for next circuit.
Why? What is there? You are required to do something by the earlier order.
Lordship, it's a legal aid matter, so sir, Lordship needed some time to study.
Appeal bail.
It's appeal matter. I'm not aware of the facts, Lordship.
You are not the advocate on record.
No, Lordship.
So who is the advocate on record?
Lordship, she is not present at.
Then why?
But actually, this is
Bail application is pending.
my lord, this is a legal aid matter, my lord. I have gone through the papers, but certain instructions, my lord, with respect to the presence, my lord, was required. So if not next circuit, my lord, one day's time. maybe-
Instructions regarding?
Regarding, my lord, the presence of another witness, because, my lord, I had received partial instruction, my lord, that one witness was there who was partially not examined. So that clarification is required from the end of the petitioner. And his wife is in touch with me, so she asked for some time to get.
See what you can do. Not today. We are adjourning. If
Lord.
not, tell us tomorrow.
Lord.
It's a bail application.
Grateful.
Forty.
40 my lord, I am for the state.
Next. Next.
Forty-two. 42 I am for the statement. But last time also they sought for accommodation. Today also.
Okay, Don will be appear here. Ashima Mandla will be appearing and she is not well. So that's why I'm praying for today's accommodation.
Let it be
Not
next
today.
circuit.
Not today. Huh?
Let it be next circuit.
What is it? What is the issue?
It's a bail application.
Not today. Not today. You prefer adjournment tomorrow if it is taken up.
Grateful, my lord.
Don't worry. We'll accommodate you till Thursday. 43.
Lordship, I'm for the appellant, Lordship. Lordship, I'm praying for leave. There's a delay of 39 days, Lordship. So,
How much?
delay of 39 days, Lordship. Lordship, I'm praying for leave to file CRAN application, Lordship.
What is it?
Lordship, it is an appeal against acquittal, Lordship.
State appeal.
Yes, Lordship.
As paid by learned counsel for the appellant, comma, matter is adjourned. How much time?
Lordship, for 1 day, Lordship, everything is ready, Lordship. Lordship, for 1 day, Lordship. Lordship, tomorrow.
To be taken up on Thursday. Give the date of Thursday.
Grateful, Lordship.
The 44 Lordship, I am for the petitioner appellant. I am praying for day after today.
Not today.
45.
Yes, my lord, I am appearing on behalf of the appellant lordship.
In which one? 45?
My lord, yes, my lord, in 45.
Yes, what is it?
My lord, this is a appeal against acquittal, my lord, on behalf of NCP. One direction was there, my lord, to serve the copy of the petition to the other opposite parties. And it has been served through post, but post has not been effected to the opposite parties till now, matlab. So my lord, it is required more time.
You are awaiting service.
Yes, my lord.
The learned counsel for the appellant informs the court that the appellant is awaiting the service report to a service report of the notice effected on the respondents pursuant to the court's earlier order dated 11/4/25. Stop. List in the next available circuit.
Much obliged, lordship.
Cases.
Item number 46. 46 onto the applicant's file. An application and a section has to be filed in this.
Application for?
For condemnation of delay.
What is the matter?
So that the matter was filed.
FAT.
before the principal bench during lockdown. Thereafter, the file was not traceable, ma'am.
For taking steps in respect of the defect, comma.
Lordship,
My lord, I am for the petitioner, my lord. This is a heaviest
Lordship, I
corpus.
come to know that the matter will be coming in the list in tomorrow list in as item number 1, Lordship. So now,
No, my lord, it's coming in the list.
actually, petitioner advocate informed me that if the matter will be come in the list in tomorrow. As
Tomorrow.
No, my lord,
number
my lord
one,
is saying
Lordship.
if it is not taken up today,
I
then
already
tomorrow
informed
talk.
this to additional advocate general.
All right.
My lord, this
It's
is,
supposed to be.
We can take it up tomorrow, not today.
my lord, can we take it up at top because my lord, 7th April, a person is missing.
Yes.
Not today.
That can.
I am representing the Union of India.
Not today, not today.
And this
Lordship,
matter,
this matter was.
and the Lordship, this is the matter for the petitioner. We have already, after receiving the writ petition from our own sources, we have searched where the petitioners. Where the persons, your Lordship, and we have already found. And if your Lordship take up the matter, we have filed the report. The persons
Yes,
concerned,
ma'am.
your Lordship, under the custody where he is.
What is it?
Habeas
Have
corpus.
Habeas corpus.
Yes.
Oh, yes, it was mentioned today.
Yes, your
Yes.
lordship.
You had mentioned it.
That is why.
Yes.
And I had informed that if the matter is not called, it would be.
Obviously.
Your lordship, and it's a habeas corpus matter, your lordship.
Then Lordship,
Please.
can you make it a short pass over? I will call.
Just wait. What is there is a report.
My lord, my lord, may I place my case, my lord, for 2 minutes?
Sir, please wait for 2 minutes. Yes. What do you have to say?
But in the writ petition, there was the allegation.
She is saying her husband is missing.
Yes, your Lordship.
Now, what do you have to say?
See, the petition person is under the custody of the Nepal police of the drugs case, your Lordship.
Oh.
This I have collected a copy. That's why. Because
Then let him file the report.
there was the allegation against the SSB. Their allegation, SSB personnel spectacularly involved and
Anyway, so
Lordship, they keep along with all the documents here, there, your Lordship, the person under the custody of the Nepal police, and the Nepal police detained with 150 grams brown sugar, your Lordship.
Can a latex copy be handed over to my learned junior?
Your husband's name?
My lord, Rajan Burman.
Rajan Burman.
My lord, there is an eyewitness from petitioner number 2 is the eyewitness, my lord, my employee. We are returning from our restaurant when SSB personnel abducted Rajan Burman in front of petitioner number 2. Police officers, SSB has not taken my complaint. But now they are saying they are across the border. How he has been abducted, my lord. Now they are saying he is in Nepal.
What will survive in the habeas corpus?
Yes.
What will survive in the habeas corpus? Nothing.
Nothing.
Let a copy be served upon us, my lord. Let
Permission I will provide.
And give them a copy.
Now the person is found, your lordship, that took the initiative.
You will have to take steps, whatever you want to do.
All the case numbers and.
Now your 2 minutes starts.
There.
My lord, kindly appreciate. No, my lord, kindly appreciate one thing. They have come up with the case that, my lord, kindly see once for a moment. My lord, paragraph number 7 as page 5. Just
You
that.
are
amendment.
arguing habeas corpus?
Yes.
Or you are arguing something else?
No, my lord, habeas corpus. My lord, I know there
Therefore,
is no
where is
pleadings,
when
pleadings are
the
not
body,
important.
when the corpus is, they have
Yes.
said where the corpus is, what will remain? Why should we see any paragraph whether he was apprehended, kidnapped, whatever?
My lord,
Now
let
they are
them
telling you where he is.
My lord,
So you have
kindly
to take-
record their submission, then where the corpus is and.
They are going to serve a copy. Take a copy.
Yes. My lord, kindly record their what is written in the report and my lord dispose it
You
of, my
go through
lord.
the copy. We'll take it up tomorrow, not today.
My lord.
Report, a copy of the report dated so and so is being handed over to the learned counsel for the appellant by respond number 1 and 3.
My lord, may I be
Respond
permitted
number
to
1
take
and 3.
exception?
Respond
May I be
number-
permitted to take exception to that report?
No.
My lord.
Respond number 3. Full stop. The matter stands adjourned for the day. What exception you will file unnecessary? No, this, give the slip back. Not required. We have already taken up. Yes. It will come at the top. As it is habeas corpus. Immediately after the bail in the division bench it will come. This is
Rupert, my instructions. My instruction.
Agenda 48. Lots. 48.
Bring for next again.
you don't want to remove the defects. You don't want to remove the defects. Then you want only in the next circuit. It should just keep pending before the court. Why do you for taking steps for removing the defects? The learned counsel for the appellant pays for some time to stop.
Agenda 49. 50.
One quickly.
51. 52. 53.
54, 55, 56, 57, 58, 59, 60, 61, 52, 53, 54, 55, 56, 57, 58, 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 3, 104, 105, 106, 106.